Welcome out to the Cayuga-Onondaga BOCES Office of Personnel Relations training on sexual harassment prevention involving staff and students. My name is Ryan Hatch. I'll be joined by Nick Mindler, and together we'll be presenting this training. The training is state mandated for all employees in New York State. Our training also includes some overlap as far as sexual harassment of students is concerned due to some changes in the law that we'll address later in the presentation. What is harassment? Harassment is any form of discrimination based on a protected characteristic or class. Harassment can include offensive behavior based on stereotypes, as well as the characteristics I'll show you in just a moment. It can also include somebody's expression of contempt or hatred for the groups that we're going to talk about now. Those protected characteristics or the classes of people are as follows. The ones that we'll be focusing on are sexual orientation, sex, gender identity, pregnancy. So per the law, there's a zero tolerance for sexual harassment in the workplace. Just because certain conduct was once acceptable does not mean it is acceptable now, and all allegations of harassment will be investigated. If somebody does engage in sexual harassment on the workplace as an employee, they may be disciplined, and that may include termination from employment. So what is sexual harassment? It's any unwanted verbal or physical conduct based on sex stereotype, gender, or pregnancy. It includes transgendered individuals. While some laws in other states might be more vague, here in New York, we're very clear that transgendered individuals are protected class within the state. Sexual harassment may constitute a crime when there's things such as physical touching, coerced confinement, or a coerced sexual act. Things that you should know about sexual harassment. The victim as well as the harasser can be any gender and does not have to be of the opposite sex. The victim can be essentially anybody who's been invited onto school property. That means an employee, student, independent contractor, subcontractor, vendor. This is somebody who's delivering paper or delivering water. And so that's why it says here it includes non-employees. The harasser, likewise, could be any of those same individuals, employee, student, a vendor, even a volunteer that's been asked to come and help out on school grounds. Things that you should probably know about sexual harassment or keep in mind as we go throughout the presentation. The victim does not have to be the person specifically harassed, but it could be anyone affected by that offensive conduct. For example, if I'm in an office and a coworker in my office is being sexually harassed, it may have an effect on me. Unlawful sexual harassment may occur without any sort of economic injury or discharge, meaning firing the victim. Under New York law, a single incident of sexual harassment may be sufficient to support a claim. There used to be a requirement that the conduct be severe or pervasive. That standard no longer applies.
So now we're going to move on to a few of the applicable laws for sexual harassment, both federally and in New York State. And really the goal of all these laws, and at the end of the day, this presentation, we want to create a respectful environment where people are treated with dignity and also treated fairly across the board. Now, while we are required to present you the applicable laws, which are Title VII, New York State, Division of Human Rights, and also Title IX, we're really emphasizing the highest burden that the district must comply with to avoid any form of liability. So number one, Title VII of the Civil Rights Act of 1964, that does prohibit sexual discrimination and harassment in the workplace. Under Title VII, a complaint may be filed with the Equal Employment Opportunity Commission, the EEOC, within 300 days. Filing an EEOC complaint is required before filing a complaint in federal court. If you need any further information on the EEOC or how to file a complaint under Title VII, please visit the link you see below. In New York State, the applicable law is New York State human rights law, which also prohibits sexual discrimination and harassment in the workplace for staff and students. And students, that is also a new addition to the New York State human rights law. So students can sue a district now for violations of sexual harassment. A complaint under this law may be filed with the State Division of Human Rights or the New York State Supreme Court, but not both. You do not need an attorney to file a complaint, and any complaint must be filed with the Division of Human Rights or against a school district within 3 years, which is an increase to the 1 year that it used to be. Again, for more information, you can visit the link at the bottom of this slide. Now, the biggest change here, we're going to talk about Title IX of the Education Amendments of 1972. There are new regulations that came out and became effective on August 14th, 2020. So prior to these changes, Title IX only applied to students, not to staff. However, beginning on August 14th, 2020, Title IX now applies to both students and staff. And what I'd like to emphasize here is, since it now applies to both students and staff, districts should be following the same set of procedures for student sexual harassment and staff sexual harassment under Title IX and New York State human rights law. So a few of the changes from the new Title IX regulations that does prohibit sexual harassment of students and employees in an educational setting. Before I get to those changes, just briefly, no person shall on the basis of sex be excluded from participation in, be denied the benefits of, or be subject to discrimination under any educational program or activity receiving federal assistance. Since the school district does receive federal funds, Title IX is applicable to each and every school district in New York State. So what do we need to know about the changes? The recent amendments to Title IX, they duplicate some of the requirements from Title VII and the New York State human rights law, but they also add some additional requirements that we're going to point out here. So number one, big change is during an investigation, confidentiality can no longer be guaranteed. So both the complainant and the respondent, so that's the alleged victim and the alleged harasser, they have an expanded right to information about the allegations being made and the evidence received. So the alleged victim can receive any evidence that the alleged harasser may give to the district, and also the alleged harasser can receive any documentation and evidence that the alleged victim provides to the district as well. All employees are required now to report conduct that may be inappropriate. So again, this is a very big change. This could be applied to a teacher, a principal, superintendent, a food service worker, a bus driver. Every employee is now required to report conduct that may be inappropriate. An employee is put on notice of inappropriate conduct that should be reported through either verbal or nonverbal communications from the alleged victim and or witness. This could be text messages, emails, or in person. But in essence, if you see something, you need to say something, or if you hear any sort of allegations, that puts you on notice. You need to say something as well, because then the district is also put on notice. Some other things, the district will offer appropriate support to both of the parties. So this could be to the alleged victim and or the alleged harasser. The district does need to put in supportive measures for those individuals. The district must conduct an investigation while respecting the free speech rights of the complainant, who is the alleged victim, and the respondent, who is the alleged accused.
So sexual harassment falls into three general sections that we're going to talk about here today. The first being sex stereotyping, the next quid pro quo, which is something for something else, and a hostile work environment, which can include things like sexual assault, dating violence, domestic violence, stalking, etc. So sex stereotyping, what is it? This is when there's conduct, either verbal or actual physical conduct, based on personality traits that are considered inappropriate simply because they may not conform to another's idea or perceptions about how an individual should act or look based on that individual's perceived sex. This is a situation where somebody say, hey, you shouldn't be doing that job. That's a woman's job, or that's a man's job, or I'm not going to do that job. That's a woman's job. It could even include something like that. Includes harassment of a person. That is harassment of a person based on sex stereotyping, and it is sexual harassment. The next big issue, or the big heading, quid pro quo sexual harassment. This occurs when a person in authority trades or tries to trade job benefits or employment decisions for sexual favors. This is offering a better working condition or threatening a worse working condition unless the person that you're making the overture to complies with a request for sexual favor or something along those lines, go on a date with you, etc. While this is something we don't see as much anymore, it does something that does happen and probably will continue to happen, unfortunately. The hostile work environment claim is typically what we see when we're asked to come in and do an investigation. It is a verbal or physical conduct that is unwelcome or unwanted by the person that is the alleged victim. It's based on sex stereotyping, gender or pregnancy. It does include transgendered individuals. Even a petty slight or trivial inconvenience can count. It could be just one time that somebody says or does something. This is a change from prior laws under the New York law that says that they used to say that you had to apply a severe or pervasive standard. You no longer have to. It could be a petty slight or trivial inconvenience. The big question is, does it alter the condition of employment or create an abusive work environment? Again, the only relevant factor that may be considered here is, does the harassing conduct unreasonably interfere with an employee's work conditions? This requirement, this factor, gets interpreted pretty broadly by courts, and it doesn't take much for the complainant in such a complaint to meet this burden of proof. So some prohibited conduct that we'd like to talk about would be inappropriate displays. These could be pictures, posters, calendars, graffiti. Could be an object, something of a sexual nature, something based on sex stereotyping that's inappropriate for the workplace. It could be a verbal or physical conduct by somebody. It could be interfering or distracting with somebody's work materials when they're not around, if that is based on their sex or, one of those factors. Some additional examples: unwanted verbal or physical advances of a sexual nature, sexually explicit or derogatory jokes or statements. We see that fairly regularly. Asking about a person's sexual fantasies, sexual preference, or sexual activities. Repeatedly asking to go on a date with somebody after they've said no. Disparaging remarks about the person's gender or body. Sexualized gestures with the hands or through other body or facial movements would also be examples of prohibited conduct.
So where can sexual harassment occur? This is another one of those very broad topics. So in essence, sexual harassment can occur wherever you're hanging out with another employee. That could be in the school building, that could be on a field trip, that could be at a sporting event, that could be at a conference, that could be at a happy hour that you have after work with some other employees. Any conduct that then can bring itself back to the workplace and affect that work environment, that can be considered sexual harassment. So sometimes we hear, well, this happened off campus at a party. We don't feel that's sexual harassment. Unfortunately, that can absolutely be considered sexual harassment. So keep that in mind. This is a very broad topic. So wherever you are with other employees, always keep that in the back of your head before you say or do something that could be viewed as inappropriate by another employee. What should I do if I see it and learn of it, or it happens to me? So as we said in the beginning, since Title IX now applies to employees, and it also is making all employees on notice when they see or hear of something about sexual harassment, all employees are now required by law to report any conduct that may be inappropriate. Sexual harassment really cannot be stopped if no one knows about it. So while that's a simple thing to say, it also directly impacts the district and each individual employee. So the district does expect all employees to comply with the requirements of Title IX or face discipline. Keep in mind, the behavior does not need to be a violation of the law to be in violation of the policy or be investigated. If you have any concern that something may rise to a level of sexual harassment, we would strongly encourage you to report that to the necessary individuals at the district. Students should also be encouraged to report any allegations of sexual harassment to the appropriate school official. While they are not required to report, like all district staff, it is still good to encourage them so the district can prevent any sexual harassment in the workplace among employees or students. We also encourage review your employee's sexual harassment policy and follow the policy. The district can make available to you all of the policies that are relevant in this case. So I would recommend talking to your individual districts to get any further information on their specific policies. Also, cooperate with management during any sort of investigation. How do you make a complaint? Again, this might vary from district to district, but they will have to designate a specific Title IX coordinator, and that could be a building principal. It could be another administrator in the district. So if you feel like your complaint was ignored, report that up to the next level. What else can I do? If you feel it is safe, this is not a requirement, but again, if you feel it is safe, inform the harasser that the conduct is unwelcome and must stop. This is not a prerequisite, but it is something that you can do if you do feel comfortable. You can also discuss the matter with a supervisor or other individual who can take appropriate remedial action and or provide you or the victim with safety until the conduct can be reported. Some additional suggestions: never discourage anyone from filing a complaint. Do not be influenced by the alleged promiscuity of the complainant, so the alleged victim. Do not end an inquiry simply because the complainant recants a prior statement. Once the district has noticed that there could be a possible violation for sexual harassment, they are obligated to act and perform an investigation. Remember any possible mandatory reporting requirements for child abuse and or DASA. Those could also be applicable in individual scenarios. And finally, educate your students and other employees about sexual harassment, district policies, and any reporting procedures.
So what are the obligations of the employer once, regarding sexual harassment, either before it happens or after it happens? Well, all school districts, all employers in New York State are required to have a sexual harassment policy calculated to prevent sexual harassment. They need to provide employees, in our case students, also with notice that sexual harassment is unlawful and will not be tolerated. How do they do that? Well, through presentations like this. They also make information known on the district's website and various board policies about that, what the school district's stance is on sexual harassment and how it'll be treated if it occurs within the district. Employers and here school districts are required to provide a means for employees and students to complain of sexual harassment. Nick just went over the reporting requirements. You can report to a building principal or Title IX coordinator. Those building principals, if they probably receive a complaint, will make that known to the Title IX coordinator themselves. The Title IX coordinators need to be trained and designated and identified on school district website and that sort of thing, so that people know who they can contact 24/7. They need to provide a means to investigate all sexual harassment claims. It doesn't need to be the Title IX coordinator that does it, but there should be a person or a group of people designated or identified as the people who will conduct the investigations into such complaints. If you're a supervisor, depending on the law that we're talking about, you have additional obligations. You don't have obligations. You don't have less obligations than other people. You just have more. They are required to report complaints of sexual harassment or any sexual harassment that you see or observe yourself. I guess that's the same thing. It doesn't matter if there was an actual complaint. It doesn't matter if the individual asked that they not be reported. You're required to make that report. Failing to do so can create liability for your employer and could result in discipline for you if it's found out that you knew of some sexual harassment that occurred and didn't report it. You're responsible for modeling best practices of how somebody should act in the workplace, and you will be liable if there's sexual harassment that occurred that you should have known about that you didn't take appropriate steps to find out about. You can't just put your fingers in your ear and close your eyes and pretend like it didn't happen. Speaking of sexual harassment liability, a school district can be held liable for sexual harassment under certain circumstances. If it had actual knowledge of the offending behavior, this would be when any employee is put on notice that something occurred. It could be from conduct that they observe. It could be from a text message that's sent to them by a staff or student, parent, phone call, an email. Anytime they learn that there's something that shouldn't have happened, that it happened, even if it's not verified, that needs to be reported. That's why there's an investigation process. So those sorts of allegations can be looked into. If the school district is deliberately indifferent to misconduct, which means they are failing to stop the behavior, they can create liability. And again, if the behavior effectively bars the victim's access to an educational opportunity or benefit, when we're talking about students, that students and staff both, really, it's a pretty low bar for any victim to reach. So the employee just has to say, it's harder for me to come to work, makes my work harder to do because of what I'm experiencing. And in the case of a student, it would be things that we've heard in the past. I can't focus on class. I'm embarrassed to come to school at all. The investigation itself, the district is supposed to designate a particular person that will conduct a review of the allegations and either take appropriate actions as necessary or advise somebody who can take those appropriate actions to do so. That designated person will collect or request relevant documents to help out in the investigation, interview parties or witnesses, and they're required to ensure that the free speech rights of the complainant, or otherwise known as the alleged victim, and the respondent, which may be known as the accused, is respected throughout the investigation. Further, through the investigation, the district needs to provide each party with an opportunity to offer evidence and to support of their position. They need to be able to offer evidence that I did it, or that this happened to me, or I didn't do what I'm being accused of doing. They have the opportunity to know what the evidence is and respond to the evidence that's being presented from the other side. They need to provide parties with notice of the outcome of the investigation and be given an opportunity to appeal the final decision if they so choose to. There needs to be a prompt and effective corrective actions taken if necessary, and those actions need to be reasonably calculated to end the harassing conduct. So a part of all this is the issue of retaliation. And just so you know, retaliation is unlawful. It's unlawful for an employer, agent, employee of employee, student, anybody involved in a sexual harassment investigation to retaliate against somebody else in that investigation because of their participation in it. Retaliation by an employee may result in disciplinary action up to and including termination from employment. Again, retaliation is unlawful under the law. A person is protected from retaliation if they filed the sexual harassment complaint. Doesn't matter if it's formal or informal. If they've testified or assisted with the investigation, whether they just generally oppose sexual harassment in the workplace, whether they've complained of sexual harassment on behalf of another employee, or if they've encouraged or assisted another in reporting that sexual harassment. Retaliation is an adverse action. When we're talking about retaliation, it has the effect of discouraging or dissuading a reasonable person from making or supporting a sexual harassment complaint. It's very broad in scope. The adverse action does not have to be job related. It doesn't have to be something specifically done in the workplace. It can include an action that occurs after an employee has been separated from employment. It could be, when we're talking about a student, it could be something done against a student outside of the school. What is not considered retaliation? It's a negative employment action, not retaliatory, simply because it occurs after the employee engaged in one of those protected activities. Employees are still subject to all the requirements of their job, even if they engage in that protected activity. So they still need to come to work on time. They need to accomplish the tasks that have been assigned to them and do them in a manner that is expected of somebody in their position.
Now we'll get into a few case studies for possible sexual harassment in the workplace. So number one, worker Ben asks coworker Alice to go on a date. Alice agrees to a date, but after the date tells Ben that a relationship is not a good idea. After a couple of weeks, Ben starts pressuring Alice to go on another date, and Alice refuses. However, Ben keeps pressuring Alice to go on another date. So first, was it sexual harassment when Ben first asked Alice to go on a date? Probably not initially sexual harassment, although I know some districts don't necessarily approve of staff-to-staff dating. However, that may happen, and if you ask someone on a date and they say yes, that doesn't automatically make sexual harassment. But is it true that Alice cannot complain of sexual harassment because she went on a date with Ben? No, that is not true. She can complain. She has a right to having a positive working environment and free from Ben's behavior. And the fact that he keeps asking and asking and asking, and she's told him no, that certainly could arise to the level of unlawful sexual harassment. Number 2, Carla is a heavy equipment operator. Her male coworkers think it is funny to tease her by saying, "Watch out, crazy woman driver," and put signs on the only available porta potty that say "men only." Is this sexual harassment? So this may or may not depend on Carla's opinion of the situation. So even if she is okay with the teasing at first, she can certainly change her mind at any time and ask for the behavior to stop. And then likely those signs would amount to sexual harassment. What if the comments were not joking in nature, but were along the lines of, "You're taking a job away from a man, you should be home with the kids," or "What kind of a mother are you?" Are these comments sexual harassment, even if the comments are not sexual in nature? So as we said way back in the beginning, sex stereotyping is a form of sexual harassment, and that's what these statements, how these statements would be viewed. They could also be intended to intimidate and cause her to quit her job. So in essence, it would be the sexual harassment based on sex stereotyping because of her gender, and likely could create a hostile work environment. Number 3, Keisha's boss, Harold, leans in extremely close to her when they are discussing work, and he frequently touches her hand or shoulder when talking. She tries to move away, but the behavior persists. Is this a petty slight or trivial inconvenience? So now that's the new standard we're working under. Before, when we used this example, it was, is this severe or pervasive enough to constitute a sexual harassment? So now, based on the new lower standard about a petty slight or trivial inconvenience, it could be. Keisha could be uncomfortable in the workplace, and there's no reason for Harold, a possible supervisor, to act that way toward her. She could initially tell him to stop the inappropriate conduct, or speak with another person designated to make complaints, and have that person speak with Harold and conduct an investigation as to what is happening. At the end of the day, though, Harold seems to be acting in a way that is inappropriate in the workplace and would likely be viewed as sexual harassment. Moving on, Leonard is a clerk typist and likes to wear jewelry. His boss, Margaret, thinks it's funny that a man is a clerk typist and that he wears jewelry. She jokingly calls him her office boy. When he applies for a position at the front desk, Margaret tells him that if he wants the job, he needs to look, quote, more normal, end quote. So, 1, why or why not is telling Leonard to look more normal sexual harassment? Again, sexual harassment includes sex stereotyping, which is what her comments would constitute. He's being harassed for a failure to live up to Margaret's stereotypes and perceived sexual orientation. So number 2, if Margaret thinks Leonard is gay and she starts asking Leonard about his private life to find out and begins speaking with Leonard's coworkers about her suspicions, is this sexual harassment? Absolutely. This is going towards sexual orientation. Neither Leonard nor anyone else is obligated to speak with Margaret about this. So he could also be a victim on the basis of gender identity, along with the other classes that we discussed. So moving through those case studies, really at the end of the day, it comes down to, why should I do anything? Well, the one very clear reason is the law requires all employees to act promptly and reasonably once you're on notice that sexual harassment exists. So the law creates an obligation for all of you to act. An individual can be held financially responsible for failing to act appropriately under the circumstances. Your continued employment may depend on it, because failing to act appropriately to known sexual harassment could result in disciplinary action to you. And finally, the state education department could revoke your certification if applicable. So that concludes our presentation on sexual harassment from the Cayuga-Onondaga BOCES Office of Personnel Relations. Please, if you have any questions about this presentation or subject matter, you may contact our BOCES, Office of Personnel Relations, at 315-255-76.